Welcome everyone for our benefits lunch break webinar series on this unfortunately snowy, or at least I woke up and saw snow on my deck this morning, snowy April 21, 2021. Thanks again for joining us for this monthly series. We appreciate the folks that have joined. For those of you that have joined us, or maybe if you are new, you know that we host this lunch break series on the third Wednesday of every month. So you can see the dates coming up for the remainder of 2021. We plan on having another lunch break series on each one of these dates. As usual, we will try to get topics in advance to you, maybe a week or two, so you can determine whether it's a particularly relevant webinar for you to attend. But of course, if you can't make it, we always record these webinars and they're made available on the firm's YouTube website, and the PowerPoint slides are available as well. If you're having trouble finding them, please feel free to contact me. But as we're developing topics, we seem to have a lot going on right now because, as you guys are aware, because of COVID, there still is a lot going on, and now we have a change in the administration, so we expect to see some more developments. But if you guys have a topic that you'd like to hear, please feel free to send it to us, either using the Q&A feature, or you can always, probably a better place to put it is in the post-webinar survey, and we encourage you to complete those, as those help us tailor and make these webinars better. One more housekeeping item before I kick off today's webinar is, if you have questions, we will try to make some time at the end of the webinar available for questions. Please use the Q&A chat feature to enter those questions. I will be monitoring it. And again, we will try to get to as many as possible, either throughout or at the end of the webinar. With that, for a lot of you that have been attending these webinars every month, I'm going to give you a little break from Tripp. I'm happy to introduce my partners, Berrodin and Jeff Gray. They are going to take you through a retirement plan update and some of the, I guess, hot topics that may impact retirement plans these days. With that, I will kick it over to Frank.
Okay, thanks, Tripp. The retirement world certainly has not been as hot lately as the health and welfare area. Certainly, we had some stuff last year with the CARES Act and everything that was going on with COVID, but now there hasn't been as much, at least with respect to the majority of our clients who would maintain, 401k and 403b plans. But there's definitely been some developments, and certainly a number of them lately on the Department of Labor side. So I'm just going to cover fairly quickly some issues about 401k plan restatements, and then some recent legislation that passed that has very limited impact, but its impact is critical to people that are subject to it, but it's not a very broad group that is covered by that legislation. And then Jeff is going to cover what the Department of Labor has guidance that they have issued in a number of areas in the last few months. They've been quite busy. So that's what we're going to try to do here. The first thing I'm going to talk about is the 401k plan restatement process. As most of you know, almost all 401k plans these days are on prototype or volume submit or pre-approved type documents. And all of those documents have to be restated for all kinds of compliance with law by July 31st, 2022. Now that may seem like a long ways off, but it's really will come up much faster than most people realize. And there are many reasons why you might want to be at least starting to think about that process, or starting that process now, especially because if you're going to make any changes, you generally might want to do that as of the first day of the year, or may need to do it as of the first day of the year. So it's reasons to start working on it now, so you can have the document in place by January 1 of 2022. And there's really two ways to look at this restatement process. you can either look at it a little bit like getting the COVID vaccine, which I just got my second dose on Monday, and I have to say yesterday wasn't all that pleasant. It wasn't horrible, but it was not great. So you can look at the restatement process that way, as something that, yeah, you have to go through in order to be protected, in order to be in compliance, but there's a little discomfort. Or you can look at the restatement process as an opportunity to really review your plan design and make sure it's accomplishing what you want. And this is where I continuously see plans that I think could be improved and be designed differently so that not only the employer but the employees get more benefit from it. And so I'm going to kind of cover some of the things that I think you should think about and look at as you're going through this process. So the first thing is always the definition of compensation. And the reason that that's number one is because that is the single, the area where the single most number of errors committed is in employers not actually using a definition of compensation as it's defined in their plan. And of course, that leads to compliance problems and potential additional contribution requirements that the employer wasn't expecting. So it's very important to make sure that what the plan provides is what you're actually using. And of course, we have some clients that have well over 100 different pay codes. So it's always a challenge to make sure that which ones are included or excluded in the definition. So that's certainly one thing to be considering. The second thing is, if your plan doesn't already have automatic contributions and automatic increases, you really should seriously consider adding that. And that's the kind of thing that it would be logical to add as of January 1, 2022, if you're going to complete your restatement before the deadline. And there's really three good reasons for having automatic contributions and increases. Number one is the very obvious one, which is if you really want your participants to be able to retire, this will significantly improve the chances that they will, because there's numerous studies, and I've seen it in my practice, that these do have a dramatic impact on the amount that people are saving for retirement. If you have an automatic contribution provision that's set at least a reasonably high level, at least 3% to begin with, and it increases up to at least really 8 or 10% of pay, or even higher, the majority of the participants will actually not do anything, and they will allow those increases to occur, and they will then be saving at a rate that would probably give them the ability to retire someday. Many employees are not contributing that much, and I do occasionally see one that has automatic contributions that is set at a much lower level, and that's probably the worst possible thing, because it leads employees to believe that that's enough for them to retire on. So that's the first reason to do it. The second is we still see lots of clients whose plans are failing the ADP test, or at least the highly compensated employees aren't able to contribute as much as they'd like. And the single biggest improvement that you can make to improve the chances of passing that test are to add an automatic contribution and automatic increase feature. It's nice if you can increase the match, but obviously there's a cost to that, and you may be able to solve the problem of the ADP test failure without even having to increase the employer's costs by increasing the match, just by adding this feature. So that's number two. And the third thing is that in the past, at least, if you made an error on somebody's pay deferrals and you missed withholding the deferrals for them, if you've ever experienced that, the employer has to make a contribution for those employees equal to either 25 or 50% of the deferrals that should have been withheld from the employee's pay. So even though the employee actually got the money in their own pay, the employer now is still having to put in a portion of the contribution that should have been withheld for the employee, and that can be very expensive. With an automatic contribution arrangement, there's a special provision that basically lets the employer off the hook for having to make any contribution for the employee's portion of the deferral. They may still have to make a matching contribution, but they don't have to make any contribution for what the employee didn't defer. Unfortunately, that provision expired at the end of 2020, and everybody's asking, and they're not getting answers yet as to whether that will be reinstated. My guess is, like many of the provisions in the tax code and others that expire periodically, they get reinstated, but a lot of times kind of later in the following year. So everybody's in this unknown period where they're just unsure whether that's going to be reinstated. I think there's a good chance it will. And so that's another reason to include the automatic contributions and increases. And then the last thing is how the employer non-elective contributions are allocated. And I see still many, many plans that just do it based on a percentage of pay. Well, that's okay, but if you do it with individual allocation categories, it basically gives the employer the flexibility to determine how much will be contributed for each participant on an individual basis. Even if you're not making a non-elective contribution, all your plan provides for is a match, this makes a ton of sense to have this provision in there so that if you ever do decide to make a contribution, you can determine exactly how much each person gets, each participant. There are some non-discrimination requirements, but in many, many, many cases, you can end up contributing kind of the amount that you would want for different groups of participants. And an example, I'm thinking we're going into a time period where employers are going to be hiring a lot of people and are going to be looking to hire people, and it may be a tight job market for a while. At least it might be hard for employers to find the employees they need. And this is one way to kind of set the employer apart, which is you can provide a new hire bonus to people that are hired of up to $58,000 by making a contribution to the retirement plan for them. And that would not be taxable to them. And that can even be done if you're hiring a new executive who's going to make, well over $200,000 a year. They are not a highly compensated employee when they are first hired. So that contribution could be made even if it's not made for any other employees, and it won't fail non-discrimination testing. On the flip side, severance payments are frequently good to be made to the retirement plan, especially for those age 59 and a half or older, because it saves the employer FICA and Medicare taxes and also saves the employee those amounts. And since the person's already 59 and a half, they can pull the money out right afterwards and have avoided those taxes. As alternatively, if they don't need the money right away, or if it might negatively affect their Social Security benefits that they may be receiving, they can leave it in the plan. So there's really no downside to putting those individual allocation categories in the plan when you restate it, but even if you don't ever end up using it. So I always recommend that be included. So those are really the things on the plan restatements that people, I think, should be focusing on. The only other thing I'm going to cover really briefly and then turn it over to Jeff is we now have the American Rescue Plan Act, which was a significant piece of legislation for a lot of reasons, but very limited on the retirement plan side. It is really critical, this legislation was, to multi-employer pension funds. So if you have any employees, union employees who participate in these multi-employer plans, this legislation essentially bailed out the ones that are in the worst shape, like the Central States Pension Fund, the Teamsters Pension Fund. If you've seen the movie The Irishman, that was about Jimmy Hoffa and the relationship with the Teamsters Pension Fund. And that fund still exists, but it was in an absolutely horrible shape, way underfunded. And essentially the federal government has said, we are going to make up the shortfall. Very good news to the participants in those plans. They are going to get their full pensions. The employers that contribute to them will eventually see a benefit from this, but there's a whole significant uncertainty as to how it's going to affect ones that previously withdrew. So we're following this legislation. There's got to be much more guidance that will be issued by the PBGC soon. And certainly everybody wonders if this is just the beginning of the bailouts of underfunded plans like of state and local governments, but that remains to be seen. But this was the first one where they've really said the federal government is going to take care of this problem. The only other provision of this act that really related to retirement plans also relates to pension plans, but these are single employer plans, not the multi-employer ones. And there was funding relief provided. It's typical that when Congress passes these kinds of laws that cost a whole lot of money, they do things like this, which is by providing this funding relief, it means employers don't have to contribute as much to the plan now, which means if the employer is not contributing to the plan, they're paying more taxes. They're not getting the deduction for their contributions, so they're paying more taxes now, and that gives them supposedly the money to pay for these other things like this bailout of the multi-employer plans. It never seems to actually work that way, which is why our deficit just continues to grow in our federal debt, but that was the intention of it. So nothing really in this new law that really impacts 401k plans or 403b plans. There are some provisions in some proposed legislation that may, but I don't think anything's going to happen on those right away. It'll probably be later this year at the earliest. That's all I have on my portion, so now I will turn it over to Jeff.
Thanks, Frank. Good afternoon, everyone. Thanks for joining us. I've got three topics to talk to you about today, three pieces of informal Department of Labor guidance that have come out recently. Actually, two informal, and then one relates to actually a final regulation that came out last year. So first, we'll talk a little bit about the recent missing participant guidance. Then I'll briefly touch on this final Trump fiduciary investment rule that was issued last year, which is the final rule that's basically dead in the water at this point. And then at the end, I'll talk about the new cybersecurity guidance that came out last week. And Frank will probably jump in whenever it makes sense. We'll just kind of talk about these and go through them as quickly as we can. We've got about 10 minutes, and if you have to sign off, that's totally understandable. You can always go back and check the YouTube page for the recording. But first off here is the recent DOL's missing participant guidance. This came out in January this year. This really followed the Department of Labor's Terminated Vested Participants Project. That was this campaign that started by the Department of Labor's Philadelphia office that then later spreads it to other regional offices. And it involved auditing of pension plans to identify missing participants, and then effectively forcing employers to find them as in order to close the investigation. The DOL's position in these really is that the plan sponsors have a fiduciary duty to reach out to terminated vested participants to tell them that they have a benefit that's available to them. And then also, of course, when someone reaches their required beginning date, the plan needs to start making distributions. The problem is sometimes you can't find these people. You send them notices, you send them distribution forms, and you don't hear back, or the mail gets returned, or your email to them gets bounced back. And so that's really the context for these Department of Labor best practices that came out earlier this year, which is how to deal with that situation. The guidance is covered in three different documents. You've got a kind of general best practices document that applies to defined contribution and defined benefit plans. There's this compliance assistance release document that's interesting to read because it kind of describes how the Department of Labor investigates these cases, the documents it asks for, and just what that investigation looks like. The last document, I think, is not that important. It's just a document that basically says we, the DOL, won't pursue plans who decide to use the PBGC's program for transferring missing participant account balances following a plan termination. So defined benefit plans have for a long time had this ability to just transfer their missing participants to the PBGC when the plan terminates. In 2018, the PBGC expanded that to defined contribution plans, and this last document is really just the Department of Labor saying, yes, if you follow those rules when the plan terminates, you're fine. So who counts as a missing participant? There's no formal definition except if you're terminating the plan. The PBGC has some rules, but generally it's any participant who terminated employment with a vested benefit that you either can't find or is just non-responsive to communications. So an example would be that you've sent out an annual funding notice and it's been returned as undeliverable, that sort of thing. The guidance that the DOL issued listed a number of red flags to consider for employers to consider with respect to missing participants. So if you have any of these, it's sort of a trigger for you to think, well, wait a minute, we might need to look at this a little bit more closely. One of the most interesting categories is that the plan has a sizable group of retirement age participants who are eligible for distribution but haven't yet taken one. And of course, you report that basically on the Form 5500 on line 6C to the Department of Labor. So the Department of Labor has kind of immediate access to that information. And then, of course, if it investigates, then it's looking for whether you have any missing or inaccurate or incomplete census data, and whether you have a policy for dealing with these situations. What is your policy? What are your practices for dealing with return mail, uncashed distribution checks, that sort of thing? The best practices document is 4 or 5 pages. It's worth reviewing. These are the main categories. I think each category probably has 5 or 6 or 10 different suggested steps. So it's important to maintain accurate census information, and that involves flagging undeliverable mail and uncashed checks, auditing that census information from time to time, and then correcting any data errors that you find. Another category is implementing effective communication strategies with participants. So this could be anything. This could be just reaching out from time to time, asking people to confirm their addresses, confirm that they have beneficiaries on file, update their contact information. Any chance you get to communicate with participants about updating contact information is good. Another example that the guidance gives is that, if you're trying to find somebody or send a document to someone who is a participant in a plan that was subsequently folded into a new plan, maybe the company was sold, use the name of the old plan so that the participant recognizes it and doesn't just immediately throw it in the trash. The next category is conducting missing participant searches when you can't find people. And this category really is just start with the easy stuff, review your other records. What other records do you have on file internally as the employer about where this person may be located? The individual may have an address on file with the health plan, for example. You could consider checking with beneficiaries. And then if none of those kind of internal processes locate the person, then consider using search engines and ultimately a commercial locator service, which I'll talk about in a minute, because sometimes these things are expensive and they don't always make sense to do in all situations. But then once you've done all that, document your efforts to find participants. It's important to document those steps so that later on, if the DOL comes knocking, you can show, yes, here are the steps we took to find these people. But there are some concerns about these best practices. First of all, they're not the law, they're not a final regulation, they're intended to be helpful, but there's some lack of clarity about certain things. For example, it's not clear when you can kind of get away with a free online search for someone versus when do I retain a commercial locator service. I think the guidance talks about how it depends on the facts and circumstances. Does it make sense to pay $500 for a commercial search for somebody who has a $200 account balance? Maybe not, but those are the sort of things that you just have to think through and have a policy for in terms of trying to find these people. There's also a couple, I think, really questionable suggestions in the guidance, like reaching out to colleagues of missing participants or publishing a list of missing participants on the company's intranet. I don't know necessarily that those are a problem from a privacy perspective or some sort of legal violation, but I think if you polled our employment lawyers and said, hey, should we post a list of people we can't find on the internet? Is that a good idea? I think most would say no. Same thing with using social media to find missing participants. That was part of the guidance as well. That seems like that's fraught with some risk. And finally, we had kind of bits and pieces of guidance about this from the past in connection with plan terminations, or in this case, we do have a memo to IRS staff about what to do with missing participants when it comes to required minimum distributions. And the memo basically says to the IRS that if the company's gone through these 3 steps, looked for records, done a commercial search, and I think sent a notice by certified mail, then we're not going to find a violation for violating the required minimum distribution rules. And it's just a very straightforward, like 3 bullet point piece of guidance, which would be nice to get from the Department of Labor. But anyway, the point with all of this is to be aware of it, to be aware that you do need to try to find these missing participants. You can't just let return mail pile up in the corner of the office. You've got to try to find them, and importantly, you need a policy and a set of procedures to make sure that you can do that and comply with your fiduciary duties to find these people in case the Department of Labor comes investigating. I don't know, Frank, have you had much? Do you have any thoughts on the missing participant guidance?
No, other than the fact that the Department of Labor has been they've been auditing on this issue very heavily lately. So as much as you may not have seen a lot of Department of Labor audits, we've certainly had a number of clients, and they've been pushing very hard on this. So I think people do have to pay attention to it.
Yeah, and I think those have been frustrating from what I've heard, because you'll find people, but then because the investigation takes so long, by the time you get to the investigation, you've got more missing participants that you had at the start, and you kind of have to find everybody to get it wrapped up, and it just sounds like a real headache if it comes your way. Last summer, the Trump Department of Labor issued a final regulations. This was an official regulation, not proposed, finalized, related to using so-called environmental, social, and corporate governance factors in determining the types of investments to include in your retirement plan. An example of that, a straightforward example would be, say your company is very, very concerned about global warming, and the folks on the investment committee say, you know what, we don't want to have any oil and gas companies in our investment lineup. Well, the final rule would have clamped down on that practice quite a bit, because it basically required plan fiduciaries to consider only pecuniary factors, meaning only the hard financial data in selecting investments. There was a provision that maybe allowed other factors to be used in kind of a tiebreaker situation between investment funds, but that would have been, I think, unwieldy and difficult to actually comply with those tiebreaker rules. But it's all kind of in the past now, because one of the first things President Biden did when he came in is issued this order to look at all regulations from 2017 to 2020 for any inconsistencies with the protection of public health and the environment. And so this rule was, I think, not surprisingly flagged, and it did become effective. So there was no way that the administration could just wipe it out. They're going to have to issue a new rule to replace it and follow the normal process for doing that. But in the meantime, the administration has basically said, this rule exists, but we're not going to enforce it. And so that's good in the sense that if you were going to rely on these factors, you have more flexibility than you used to, 6 months ago. But conceivably, since it's still the law, a private litigant who believed that you relied on inappropriate factors could potentially still point to that regulation that still exists until it's replaced. So that was just a quick update on that. Let's talk about the final, or the new cybersecurity guidance that came out just last week. Again, this is informal guidance. It's not any sort of final rule or anything. It comes out of several high-profile court cases that involve cyber theft of participant account balances. I don't think any of these cases, I guess, in my view, that I've read were all that compelling. I mean, in a couple situations, you had a large record keeper who just fumbled the ball in an interaction with someone pretending to be a participant, and gave away too much information that allowed that thief to basically go in and access participant account balances. I think there's another case involving an employer who allowed the office manager to basically set up the 401k plan using the office manager's Yahoo account or something. And so these are, I think, kind of not that interesting cases because it's clear that someone just made an error. They don't really go into detail, I don't think, too closely about who's necessarily responsible for what. But this is happening, and the Department of, in terms of this is happening, and the Department of Labor has a focus on it, and it's good to understand what these best practices are so that you can be aware of it and anticipate whether, you know, there may be some more formal guidance that comes out about this in the future. But basically, it's 3 documents. You've got a set of best practices for retirement plans. You've got a set of online security tips that you could conceivably give to your participants. The participants are kind of the target audience for these online security tips. And then you have tips to you as the plan sponsor for hiring a service provider with strong cybersecurity practices. You know, the fundamental point with all of this is that cybersecurity is a fiduciary obligation that employers can't ignore just by pointing to the record keeper. I think that's the key point. When I talk to clients sometimes and you talk about these things, their thought is, and it's understandable, but their thought is that, well, wait a minute, I'm not the one running the cybersecurity processes for the accounts on these plans. I'm sending some data securely, but how a participant accesses his or her account balance, that's all on the record keeper. Well, it's true in the sense that the employer probably has a limited ability to control cybersecurity within the record keeper's platform on a day-to-day basis. But the fact is that the Department of Labor kind of indirectly puts that requirement on the plan sponsors because the plan sponsors have a fiduciary duty to prudently select and monitor the service providers. And that selection and monitoring obligation applies equally to the service provider's cybersecurity practices. So that's really what this guidance is about. It's directed towards vendors about their best practices, and then it's directed towards employers about how to then vet those vendors with respect to those practices. So the cybersecurity program best practices document, like I said, is really directed towards vendors. We won't go through each one of these, but this is a list of items that these vendors need to be doing in terms of protecting participant data and participant account balances. So these include things like having a formal cybersecurity practice, having a third-party audit these security controls, having strong access control procedures. That sort of what went wrong in these other cases. They just, the large record keepers in this case didn't have good access control procedures. The telephone interaction resulted in disclosure of too much information, and then just making sure that the data is subject to these independent security assessments and audits. So again, more things just to be aware of. And I point these out because when you go to select a record keeper, these are the sorts of issues that the Department of Labor expects you to sort of investigate or ask the record keeper about in connection with deciding whether to retain a particular record keeper or other service provider. Could be a financial advisor, anybody who might get sensitive participant data. Next slide. So here, I think the most relevant topic or relevant document for employers is this tips for hiring a service provider with strong practices. So at a minimum, the DOL wants you to ask about service provider security practices. You know, if you get this document from a record keeper or another provider and you just sign it without reading it, without paying any attention to these things, that's where I think you could run into problems. You don't necessarily have to do all the things in this guidance, but you want to make a good faith, reasonable effort to do the things that are suggested here. So you'd want to look for providers that use an outside auditor to test those security systems, and then will allow you to review those audits. You also want to look to the service provider's track record. So there may be a track record of security breaches that's in public news reports or litigation, and you want to find out what their response to those past security breaches was. You want to find out if the provider has insurance for this kind of security breach or cyber theft, and whether that insurance would cover you as the plan sponsor, or does it solely cover the provider or the record keeper. And you also want to negotiate contract provisions really with an eye towards all of these things. If the contract puts all of the cybersecurity risk on you as the plan sponsor, that's a problem. And so you want to be able to negotiate provisions in there that require the record keeper to comply with at least industry standards, security standards, to get these third-party audits, to keep participant data confidential, to let you know when there has been a breach. You know, that's important. To make sure that the service provider has adequate insurance and that they've made a contractual promise to do that. And then also just that they'll comply with all laws, including laws related to protecting participant data. The final document in this suite of documents is the online security tips, and again, these are directed towards participants, and they're just general tips. They're tips for keeping passwords secure, monitoring account activity, updating your contact information. I think, and these are good tips. I don't know that you necessarily want to hand them out with the Department of Labor heading on the top, but you could, of course, rework them or add them to another communication that you might be sending out to participants. So, and also, you may already be communicating these things, and your communications may be tailored a little bit better than the Department of Labor's tips. So just think about communicating tips to participants and whether the DOLs are better than what you're handing out right now. They may or may not be. So those are the main pieces of DOL guidance regarding cybersecurity. Frank, have you had many clients ask about this in the week since it's been out?
Yeah, there's definitely been some questions. I think the biggest thing that I'm concluding is that this is going to lead to even further probably consolidation in the record keeper world, because as you probably know, there are several record keepers that have kind of provided these guarantees that if there's anything that is stolen or whatever from a participant's account, so long as they haven't done certain things like given away their password or whatever, they will stand behind it and make the plan whole. So once you have some providers out there that are doing that, it seems like the other record keepers are really going to have to provide the same thing, or eventually it'll be probably a fiduciary issue that you'd be taking a risk not to go with one of those providers because of the possibility that this could happen. So I think that whole contractual stuff and seeing what guarantees the record keepers are providing is going to be critical going forward.
Even though this is informal guidance, it certainly seems like it, at a minimum, gives a plaintiff's lawyer just a roadmap for how to walk through a deposition with a plan fiduciary about the selection of a provider, because I could see some plaintiff's lawyer just going by step, did you do this? Did you do that? You know, these tips are intended to be helpful, but there's a downside to it too. Anyway, I think that's it. That's our presentation for today, and we might have had some questions. I'm not sure.
Yeah. So, what excites me about this cybersecurity guidance the most is in the spirit of misery loves company, I am hoping that this is just the tip of the iceberg, and that much more is to come, and that you, Jeff and Frank, can, soon share in the joy that I call HIPAA. HIPAA for retirement plans, if you will,
Right.
and talk about protected retirement information.
Let's hope
So
not.
I think maybe that's coming soon. So far we only got one question, but if you have some, feel free to submit it yet in the question and answer. And this relates, and I'm going to try to answer this, Jeff, and then you can tell me immediately that I'm wrong. This relates to the cybersecurity guidance, and it says, is it only for ERISA? Does it apply to plans that are not subject to ERISA? And I guess my response is, these aren't requirements. They're not laws. There's no requirements for ERISA plans to follow them. Rather, they're best practices, right? Like they're tips that you probably should follow, that again, best practices. And while they were released by the Department of Labor, and the Department of Labor generally doesn't have jurisdiction over non-ERISA plans, that doesn't mean that they're probably not still best practices for plan sponsors of non-ERISA plans. Am I wrong on that one, guys?
Yeah, I don't know. We'll see what Frank says. I agree with that generally, right? It's the best practices are directed towards ERISA covered plans, but I think it's still worth reviewing them and considering them for purposes of your non-ERISA plan.
Yeah, I agree. I don't think they necessarily are. The Department of Labor has jurisdiction here, but that doesn't mean that it's not going to be used against somebody if they haven't followed kind of those best practices.
Yeah.
Well, gentlemen, you did a tremendous job, because that's the only question we have. So thanks to my colleagues Frank and Jeff for joining us this month. And remember, the third Wednesday of May, we will be back. Again, we will try to circulate a topic at least a week or so in advance. But with everything going on, that could change at any point. Again, thanks for joining us. And if you have a second, please feel free, or please, we encourage you to complete the survey. And I hope everybody has a good month. Thank you.